that is practical, a practical monitoring and evaluation process, whereby in a particular year, a judge will have to give an account to the system, be that state judicial service system, be that to the office of the chief judge of the state, be that to the office to National Judicial Council, but there has to be an institution that will be saddled with the responsibility of monitoring and evaluation of performance of judges. That is one key factor that will make a judge to sit up. When a standard has been set that you must deliver minimum of 3 judgments in a year, every judge will seek to achieve that, and then
bring a case to an end.
And bring a case to an end. Nothing says that a case should last for long. The shorter a case is, even the better for the judge who is hearing the case, because the memory will remain sharp with the issues that have to do with the state. You recall part of the thing, although not inside this reform, but part of the thing that is required is when matters become so hot, when issues have become so much that there is need for expedition of the process. The law did not say that a judge will not sit over the weekend. The law did not say that. A judge can sit on Saturday.
So why don't they sit on weekends?
The judge can sit on Saturday, but it has not become the practice in Nigeria. You recall that even in Britain, of course, you know, most of our laws are patterned after the received English law. Even in Britain, when there was this London riot, the latest riot that happened in London, the magistrate and the judges sat even over the weekend to dispense expeditiously the issue that had to do with the trial. Some people were sentenced even on Sundays. And so these are some of the things that we need to look at. Must we sit only Monday to Friday? A judge can afford to sit on Saturday. The law has not come against it. So that's really part
if
of
there are many cases waiting, they can't sit on Saturday.
They can sit on Saturdays. And more so, in order to ensure that there are not too much workload on a judge, there has to be appointment of more judges to the bench.
But Mr. Nzeakor,
there's need for that.
Remember that their work also depends on the ministry.
Yes.
And in the ministry, work is from Monday to Friday.
When we talk of reform, we are talking of shifting from the status quo to where we want to go. Okay. So we cannot begin to talk of ministerial bureaucracy in matters like this.
Okay. We've since been joined by Mr. Liboros Oshoma, also a legal practitioner. Good morning.
Good morning. Always my pleasure. Thank you for having me.
Thanks for coming. Now we're looking at the reform in the justice sector, the justice system, and he's been telling us about the things that are to be, well, the main issues. I remember that the CJN mentioned specifically the issue of separating the Commissioner for Justice
and the Attorney General,
in the states and at the federal level. In what way is that going to affect what is currently in place?
Yes, if you look at the system, it's like merging the office of the secretary to the state or the federal government with the chief law enforcement officer of the state or the federal government. And also, you find out that in almost every criminal cases from the magistrate court, you need the advice of the director of public prosecution to determine whether to go on with prosecution or not, because you need a lawyer to at that level to look at the file to say, with the fact that we should be able to establish a prima facie case against the accused persons. And so you find out also that you have heaps of files waiting at the DPP's office for advice. Matters come up in court, and then the prosecutor stands up to say, well, we're waiting for the file had been sent. I don't have the file here. The file has been sent to the DPP's office, and we're waiting for advice. And so because you have that office doing the job of a secretary and then the job of a legal advisor, and they will always tell you, you know, we have short of staffs here, and so we need more hands. So in the same vein also, I also want to take it from the last statement of my colleague. If you go to some states, if you find there are some matters that are filed this year that are already at almost at judgment stage, like in Ogun State, because they have fewer cases and more judges. But in Lagos State, for example, judges are human beings. You come to your court in the morning, you have about 45 cases on a list, and you have 10 trials for that day. There's only little that you can do. You take 3, and then sometimes also, depending on the nature of the case, I've had cause to sit down in court. My matter is number 12, and I'm in court till 4 p.m. And you depend on the complex nature of the case. There are some cases that ordinarily you think, okay, this is a simple application. The lawyers will just come in and then agree and then move on. The lawyer on this side will argue. The lawyer on the other side will argue. And also the judges in some cases, because now a judge told us recently in court that these days they try as much as they can not to even interfere, because any little thing now you hear them saying, look, the judge had departed from his position as the arbiter and moved into the arena. And so they allow you, instead of having to actually manage the case and the time, they allow you all time to argue frivolously and all of that. And so some of these issues actually gave rise to the front loading, the initial reforms that came, that look, now instead of this rigorous adjudication and advocacy in court, that you should front load all your documents. You don't need to take the lawyer on the other side by surprise. So just everything you need to, all the document, all the evidence you need in this matter, just put them in once. Let the lawyer on the other side put his own in once, and then you just come. Pre-trial stage, you can even call the parties and say, okay, which one are you contesting? Which one are you agreeing to? And that will make, that ordinarily ought to save time. And then also the fact that the judge writes, on longhand, he had to record almost everything. They tried to introduce, recording in court. But in some of these issues also, you still find, if you do the recording, you need to transcribe. And the judge will need to write judgment because he needs to capture almost everything that transpired and all the issues in his judgment. So you find all of these reforms as a motion without movement. We really need to address the main issue. You have arbitration, so that we should be able to separate not every matter that comes up that should go through the rigors of trial. And that's why in some cases lawyers are advised to go through the process of arbitration, look at the matters and see.
If I could take you up on something you said just a few seconds ago. When you have a situation where all of those facts are expected to be front-loaded, delivered, is this the norm now? Or
almost all the states now, with the new rules,
they will ask all lawyers to present.
If you're filing your claims now, all your evidence, all the documents you intend to rely on, just front load them.
Has that in any way helped with the speedy dispensation?
When it started, that's where I'm going to now. When it started, it helps, in a little way. But you find out that, like I said, that it's a place like Lagos where you have 15 million people with almost 5,000 cases filed annually or monthly, and then you have 56 judges having to adjudicate over these matters, with some of them even on official assignment outside the state. Some of them even handling tribunal matters. Some of them handling tribunal of inquiry over some unrest in some part of the state. And there are some cases, you see a magistrate tells you, look, I am sitting in Lagos today. I have another assignment in Ikeja, and so I might just sit for 2-3 hours so that I'll be able to attend to that assignment. But if you have, let's say, 150 judges in Lagos, and I know with the money at their disposal, the Lagos State government can afford that. You have about 150 judges. The cases, and then also with all of these structures in place, the cases would be well managed. But with the influx of cases, and then the same number of judges, they are human beings. There's little that they can do.
Earlier you said a judge may have, for instance, 45 cases.
Yes.
Can a judge not determine, I can only take so many cases per sitting, and tell the court
In that case,
that they should not